Jim Bendell, and I'm an attorney, and I practice in the field of elder law. So what does an elder law attorney do? Well, part of what we do is very traditional areas such as prepare wills and trusts for the passing on of assets after a person has died. And I think most people are familiar with that field of law. But part of what we do also is to prepare and help people manage their assets while they're living. And there are various tools that we can use to have this accomplished. Trust can be set up for the management of property. Another one is power of attorney, which is, I always thought was a strange expression because it really has nothing to do with an attorney. It's a document whereby you empower somebody else to handle your financial affairs. It sometimes happens that as a person ages, this is only sometimes, that their ability to handle their finances is impaired. So before this becomes a big problem, it's very common for people to execute a power of attorney. Typically, they'll give the power to their spouse, or sometimes to their adult child or adult children together to act on their behalf, so that when they're not able to handle their financial affairs, this other person can act for them. A somewhat similar but more dramatic form of financial protection would be a guardianship. In a guardianship, you have a situation where a person files a petition in court and asks for a court declaration that a disabled or impaired person is not able to handle their affairs and that this other person would act on their behalf. Now, under Idaho law, that's a pretty big step, and it shouldn't be undertaken unless it's really necessary. In other words, it shouldn't be done frivolously. But there are certain circumstances where, for example, a power of attorney is not enough to protect an impaired person. Because if you execute a power of attorney, say giving your adult child, one of your adult children, to handle your financial affairs, you still have the power to enter into contracts, to contract debts, and so forth. So there are some people, unfortunately, who take advantage of elderly persons by convincing them to sign contracts for home repair and so forth and so on, and their assets can be dissipated. So in extreme cases, sometimes a guardianship is that additional step needed over and above the power of attorney. Another thing that an elder law attorney does is to help people plan for their medical care. For example, one of the documents that can be prepared in conjunction with an attorney is a medical power of attorney, sometimes called a medical proxy. And this is a document that says, in the event that you are seriously ill and unable to communicate with your doctor, that the doctor can look to this other person to make medical decisions for you. Now, obviously, the person that you designate as having this power of attorney should be somebody whom you trust completely, and you should discuss with that person your personal values and views as far as end-of-life care. Another thing that an attorney can assist a person with is planning for the payment of long-term care, long-term nursing care, assisted living, and so forth. As you know from previous speakers, long-term care can be very expensive. And if you're all the way up to full-blown skilled nursing home care, typically you're going to spend over $6,000 a month in the state of Idaho. Unfortunately, only 7% of the population has long-term care insurance. Sometimes it's hard to get the insurance if you have prior health problems. And unfortunately, some medical insurers who are in that market have come into the market, taken the premiums, and then left the market, and people are stuck without insurance. So how do you pay for long-term care? Well, Medicare only pays for up to 100 days of long-term care, and that's after a hospitalization. So Medicare is something we've all paid into our whole life, and it's something that we have as an entitlement program. Unfortunately, it's not here to pay for long-term care and assisted living. So In the absence of insurance, a lot of folks, I guess the default mode, I would call it in this country, is to have Medicaid pay for long-term care insurance. Now, Medicaid differs from Medicare in that Medicaid is considered a form of welfare. In other words, you have to have asset and income qualifications to get Medicaid. If you're too rich, and I put that in quotes, in other words, if you have too many assets or your income is too high, you can't qualify for Medicaid. One of the things that an elder law attorney can do is to help you with Medicaid planning. Because when Congress passed the original Medicaid law, a couple of things happened. First, some folks were giving away all their assets a week before they needed a nursing home in order to qualify themselves as Medicaid. Sometimes you could give up to $1 million to your heirs. So Congress passed laws which said, look, we're going to have a 5-year look-back period. And so if you gave away assets during the past 5 years, it's going to incur a period of time where there's a Medicaid penalty. And that period of time is determined by, the number of months is determined by taking how much money or assets you gave away divided by the average cost of Medicaid in your state. So if you gave away, say, $60,000, you would be disqualified from getting Medicaid for a nursing home by $60,000 divided by 6,000 is for 10 months. But then Congress also realized that an overly severe application of impoverishment would also result in spousal impoverishment for the spouse who's not in the nursing home. So there are various rules and regulations that say, okay, look, the spouse who's not in the nursing home is going to be allowed to have a certain level of income and a certain amount of assets. And what the attorney can do is help do the financial planning, help you shift assets from countable categories to non-countable categories. And I won't go into all the details now, but it can be quite complex. The rules are at least an inch thick when you talk about the federal and the state rules that apply. Now, another thing that people have to consider if they're talking about long-term care, especially for veterans, is you know from the previous speaker that there are some veteran benefits that you get by the mere fact that you're a veteran, you automatically get them. Other ones, like aid and attendance, have a financial qualification, so that if you have too many assets or too much income, you don't qualify for aid and attendance. In a perfect world, the aid and attendance financial qualifications and the Medicaid ones would be exactly the same. Unfortunately, they're not. So you may have a situation where your financial situation makes more sense to go with aid and attendance, or maybe to go with the Medicaid route, depending on how your assets and income is set up. So I'll say likewise afterwards to answer any questions you have. It was a pleasure to be invited here. Thank you.